All right, the battle to protect life continues. As yesterday, the the Fifth U.S. Circuit Court of Appeals heard oral arguments regarding the FDA's approval of the abortion drug mifepristone. Now, last month, a federal judge ruled that the FDA broke the law when it initially rushed its approval. What did we learn from yesterday's hearing as the judges noted significant flaws in the government's argument? Joining me now to discuss this is Lathan Watts, the Vice President for Public Affairs at Alliance Defending Freedom, which argued before the court yesterday. Lathan, welcome back to Washington Watch.
Thanks for having me.
So tell us about yesterday's hearing and kind of your characterization of what took place.
Well, it was a very interesting hearing. It went on, quite a while. The judges even allowed a little extra time for both sides because they had asked so many questions of both sides' attorneys. The judges asked a lot of very probing questions to both sides. I thought both attorneys argued well. There were definitely, you try not to read too much into oral argument, but there were definitely some encouraging exchanges between both Aaron Hawley, who argued it for ADF, and between the attorneys for the FDA and for Danco Laboratories. So I suspect we will get a decision, hopefully relatively soon. This is no longer on an emergency basis as it was before, so probably not as quickly as the decisions came out prior to this. But we will wait and see what the Fifth Circuit decides to do, and then we will evaluate how best to move forward. But the key thing is, when this is all said and done, hopefully there's finally going to be some accountability for the FDA. No government agency should be above the law. And when they violate the law, there should be accountability for doing so. And the FDA has done that and put a dangerous drug on the market that never should have been there.
So why is this no longer on an expedited basis?
Because when we started the litigation at the district court level, we filed a motion for a preliminary injunction, which basically would have taken the drug off the market while the litigation proceeded. And then the FDA appealed that injunction on an emergency basis to the Fifth Circuit. The Fifth Circuit ruled in our favor on most of the injunction, but not all of it. The FDA then appealed to the Supreme Court on an emergency basis. The Supreme Court then stayed the entirety of the injunction while the litigation moves forward. So everything that has led up to this at this point was on an emergency basis, but on the injunctive relief. And so now we're actually into sort of the merits of the case. But, it was encouraging to hear Judge Ho mention multiple times yesterday that pregnancy is not an illness. He even asked the attorney from the DOJ representing the FDA, we just celebrated Mother's Day. Were we celebrating an illness?
Right.
And, pointing out that the FDA had to qualify pregnancy as an illness to approve mifepristone and to say that it has a meaningful therapeutic benefit to the illness that is pregnancy. So, as I said, we're cautiously optimistic, but we'll wait and see what opinion comes out of the Fifth Circuit. And if they do rule in our favor, I would expect the other side will probably appeal to the Supreme Court again. So we may be back at the Supreme Court on this issue.
So, Lathan, for the benefit of our viewers and listeners, at present, where does the use of the abortion drug stand?
So currently, because the Supreme Court stayed the district court's injunction against the drug is still on the market. And the FDA, as we noted in our case, has lifted basically all the safety protocols that they originally implemented when they approved the drug. So those safety protocols are not there, which makes this case all the more important, because the safety protocols, at the very least, if those were in place, would reduce the possibility of very serious health implications for women who take this drug. Mm-hmm. So we obviously want the drug off the market because it is dangerous. That would be the best case scenario. I think the second best case scenario would be those safety protocols are put back in place. And at the very least, I think our litigation has brought to light the dangers of this drug, and hopefully women and girls out there who are considering this will now ask some serious questions and hopefully make a better decision, both for their own health and for their baby.
Right. And I hope that these pharmacies that are going down this path that the FDA has laid out will think twice before they decide to start distributing this based upon the uncertainty of this court case. Because if they put all this in place and the court rules in favor of women and unborn children and says the FDA violated the law and can't do this, they'll have to do a lot of backtracking. Lathan, thanks so much for joining us. Appreciate the update.
Yes, thanks for having me.
Absolutely.